Good morning and welcome to the Chamber of Commerce, Southern New Jersey's virtual presentation entitled, Don't Just Do Something, Stand There, a modest proposal for a model standstill tolling agreement. My name is Christina Renna and I'm President and CEO of the Chamber. It's my pleasure to welcome all who have logged on to join us today. I'm extremely grateful to today's speakers, Jonathan Lipson, Harold E. Cohn Chair and Professor of Law at Temple University, and Norman E. Powell, Esquire, partner at Young, Conaway, Stargatt, and Taylor, LLP, who recently authored an article on today's topic. We will be hearing from Jonathan and Norm momentarily, but I did want to thank them in advance for joining us. A few housekeeping items before we begin. In a moment, I will formally introduce both of today's speakers. Throughout the duration of their presentation, the chat function at the bottom of your screen will be open. So I encourage you, as Jonathan and Norm speak and go through their presentation, should you have a question or comment, please feel free to type it in the chat function. I will be looking at those throughout the presentation, collecting those. And once our speakers do get through their formal presentation, we'll then engage in a Q&A session with them and answer as many questions as we can that came through on the chat. If for some reason we don't have time to get to all of the questions, don't worry. We'll make sure we get those questions to Jonathan and Norm after the fact and get answers for you to the best of their ability and circle back with you. So not to worry about that. And as always, just like our in-person events, we do survey all of our members after our virtual events. So if something comes to you after the fact, an additional comment or question you maybe didn't think of during our hour-long presentation today, feel free to write it in the survey. And again, we'll make sure we get it to Norm and Jonathan at that point and get you an answer again to the best of their ability. So with those items out of the way, allow me to formally introduce today's speakers. I will start with Jonathan Lipson. Jonathan holds the Harold E. Cohn Chair and is a professor of law at Temple University Beasley School of Law. He teaches contracts, bankruptcy, corporations, commercial law, lawyering for entrepreneurship, international business transactions, and a variety of other business law courses. In addition to Temple, he has taught at the law schools of the University of Wisconsin, the University of Pennsylvania, and the University of Baltimore. Jonathan's research focuses on corporate governance, restructuring, and contracting practices. He has published in many of the nation's top law reviews, including those of the UCLA, Boston University, Notre Dame, and Southern California law schools, and his work is frequently cited by the United States Supreme Court, U.S. Court of Appeals, as well as leading business courts such as the Delaware Supreme Court and the Bankruptcy Court for the Southern District of New York, among others. He is also a co-author of Contracts, Law, and Action, the nation's leading casebook that takes a law and action approach to contract law. Jonathan is a graduate of the University of Wisconsin with a BA with honors and JD, where he was the note author of the Wisconsin Law Review. Thank you so much for being with us, Jonathan. Also with us today is Norman M. Powell. Norm, with widespread preference for alternate entities formed under Delaware law. Parties to large transactions turn to Norm for an informed review of their attributes and governance. Working closely with lawyers immersed in these transactions, Norm provides guidance and renders opinions regarding all pertinent aspects of the laws governing Delaware entities, regardless of the jurisdiction governing the deal itself. Norm takes a proactive approach to this essential but easily overlooked detail in the deal-making process. He handles all issues relating to the formation of governance of Delaware entities, as well as to their authorization of transaction and perfection under Delaware law of security interests granted by such entities. Since a disproportionate number of these transactions involve commercial real estate, Norm's background as a former real estate lawyer is invaluable and very rare. A sought-after speaker and prolific writer, Norm is also an elected member of the esteemed American Law Institute, for whose publications and continuing legal education initiatives he advises on various aspects of law. Norm received his undergraduate degrees from Georgetown University and his JD from Villanova University Law School. We are so thrilled to have such accomplished guests with us this morning on such an important and critical topic. Now allow me to turn the program over to Jonathan and Norm. Gentlemen, the virtual floor is yours.
Great, Christina. Thank you so much for that very generous introduction. I am Jonathan Lipson. With me is Norm Powell. And we'll spend the next hour or so talking about a project that Norm and I recently undertook to try to address problems of uncertainty for people in business due to COVID-19. We can talk a little bit about the background of the project as we go, but the basic idea is that we've published a form of an agreement that we hope that people in business can use to try to stabilize economic relationships that might have been destabilized by virtue of the crisis. Because we're lawyers, or at least we play them on Zoom, we need to start with a disclaimer. Norm, would you like to do the honors?
I'd be happy to. We're delighted to be with you this morning, and we're hopeful that our work on this project can be of some use to you. That said, neither of us is in a position to undertake to provide specific legal advice. We simply don't know about anyone's particular circumstances, nor are we in a position on today's call or in any follow-up to this call to run the traps we would have to vis-a-vis conflicts of interest and things of that nature. So we're intending to present some information to you of a general nature. Hopefully this will stimulate some thinking and maybe help you to find a better path out of whatever predicaments you might be facing in this uncertain time. But we are not undertaking to represent anyone in particular. We're not your lawyer. You're not our client.
Great, thanks, Norm. And what you see in front of you is the disclaimer, the sort of standard disclaimer that's available in the slides that we're going to share with you in a PDF form. But you'll see here also a link to the article that we wrote about the form contracts that we created, as well as the agreements themselves. And so if you want further information about how to do the things that we'll be talking about today, that is where you go. So let me just sort of set up the problem and the solution. The problem, I think, as everyone understands, is that almost every major commercial contract is likely either to be in breach right now or will be in breach probably in the near future. This is all due to the financial and economic consequences of the coronavirus pandemic. And there are essentially two responses that people typically have to the prospect of breach of contract. Either people want to deny it and ignore it, hope it goes away, or they want to fight about it. They want to litigate. And our view is that neither of those choices, while tempting, is especially helpful, especially in light of how uncertain things are. We think that there's a better solution than litigation or denial. And that solution is the model standstill tolling agreement that we'll spend the next 45 to 50 minutes talking about.
So we a little bit about how we came to do this. Christina was very generous in introducing both of us. Jonathan is a bit too modest, I think. He contacted me in early April with an idea for this project. And it really started with the idea that, you know, there are plenty of people who probably are going to find themselves on one side or the other of a contract that's in default. Some of them may have lawyers to whom they regularly turn for advice in such things. Others may be in a position to hire lawyers, but a great many may not. They may simply not be in a cash flow position that lends itself to that. How can we be of help to them? And this was really Jonathan's idea that we worked on together. The model form that we'll be reviewing is not perfect for everyone, and it doesn't have some of the, you know, the bells and whistles, if you will, that one might expect in a customized, you know, highly negotiated document in a circumstance like this. But we've endeavored to cover sort of the main things that we think are appropriate to cover in such a circumstance. And maybe most significantly, we wanted to encourage people to just slow down for a moment, hence our title, Don't Just Do Something, Stand There. We have this perception, and I think it's borne out from most of the conversations we've had, that many of us, let's suppose we're owed money or owed performance under a contract. If that's not forthcoming, we're angry, right? Someone who we trusted agreed to do something, and they signed a document agreeing that they would do that something. And the document may very well specify certain penalties if they don't, and rights that one might have if they don't. And yet, in these uncertain times, one has to wonder, is that really the best thing to do as we go forward? We're all familiar with that old adage, you can't get blood from a stone. You can sue to collect money that's owed, but they don't hand you a check on your way out of the courthouse. You have to collect from resources that are in fact available. Moreover, we think that if one were to try to find someone else to take over, right? If you're still selling stuff and you got capacity and no one's buying it, you got to find another buyer. There are entire segments of our economy that are temporarily shut down. And on yet another similar but distinct level, we think there are some very healthy, productive, and worthwhile commercial relationships that should be preserved. And that suggests going slowly and recognizing that, yeah, we all made the promises we made, and then COVID happened. So given that, what is in fact the best, least painful way forward for us? So that's what we're going to try and do today as we go forward. Jonathan.
Yeah, that's excellent, Norm. I think that's right, that we're trying to help people in business, in particular those who may not be in a position to hire counsel or would prefer not to for any number of economic reasons, to be able to have, frank, clear, effective conversations with their contract counterparts to introduce a little bit more certainty into their lives, to bring the blood pressure down in order to sort of get to a point in time when we hope things do become more clear, as we think will happen in the not too distant future. So the roadmap is fairly straightforward. We'll talk first about the problem. And as we said earlier, one of the effects of COVID-19 is that it has led to, the massive potential for breaches of contract. And the responses will be either denial, we're just not going to deal with it, or dispute. And the solution, we think, is to do neither of those things, but instead to negotiate an interim agreement in which the parties agree not to take up arms and fight in court, at least temporarily, and not to do anything else that would harm the relationship, to freeze the relationship in certain respects while we wait for things to become more clear.
So in terms of what sorts of breaches we're speaking of, when we get into the contract, you'll see we've used the nomenclature of two parties, a debtor and a creditor, someone who owes perhaps money, perhaps a performance, deliver a shipment of widgets or whatever it might be. But we use that nomenclature just for convenience. You can call the parties whatever you want. But we're speaking, for instance, of payment defaults, as might obtain under a lease or under a loan agreement or what have you, the covenant defaults that often come along with those. And we'll talk about that a little bit when we speak about the scope of things that are intended to stand still under our standstill agreement. Many's the time someone is a party to a loan agreement that says you'll pay X dollars on the first of every month, but there are also various financial covenants that, as a practical matter, get tripped when you enter into an era of various defaults. We also find, as we say, there are some performance type breaches that may occur, production or delivery delays and what have you. And then we want to spend just a little bit of time talking to you, I guess in the next couple of slides, principally about, you probably hear these terms bandied about, material adverse event or act of God or force majeure for those who like the law French. There are a variety of ways people say, well, I know I agreed to do such and such, but then this crazy thing happened and that changes everything, doesn't it? Well, we want to explore the vagaries of whether in fact it changes everything. And our takeaway from the next few slides, if I can sort of presage, is it's not that clear, it takes a lot of time, and it takes a lot of money. Jonathan.
Exactly. Well put, Norm. I think one of the best arguments against litigation is that the law that is triggered in this context is extremely fuzzy. It's extremely unclear. It takes different names, and we don't need to spend much time at all talking about the names of the different legal doctrines that might be engaged here. But one thing to understand is that if you are having a heated discussion with a contract counterpart, they might throw some of these terms at you. You might be tempted to throw some of these terms at them. And you don't obviously need to be a lawyer to have the basic intuition that these are terms and concepts and rules that really speak to or attempt to speak to extraordinary situations that precede and then trigger the breach of a contract. So the law French version of this is called force majeure, and it's essentially a defense to a claim that a contract is breached. One party might say, well, I couldn't perform because of the pandemic, and I don't have to perform under this idea that, that we're protected by force majeure, or maybe even there is a clause in the contract that says, in the event there is an act of God, some extraordinary force outside of our control, then I don't have to perform. As a general matter, courts, I think, are cautious about enforcing these things. They've developed tests to decide whether they will do so. Number one, the claimed event of force majeure was beyond the party's control. Number two, the party had tried to perform, but they couldn't. As I said, we don't think you need to worry too much about the details, but it's a term that you might hear, and it's one of the several reasons that we think it's one of the several sorts of litigation tools that we want folks to try to avoid if possible.
And there are a number of cases currently pending, many of them by some very large outfits like ExxonMobil, for instance. And this begins to hint at why we have the view that it's very expensive and time consuming to pursue some of these things in litigation. Just to give you a very light flavor, one of the cases here, level 4, involves, somebody was going to buy one yoga studio was going to buy another yoga studio. And one of the terms of the purchase contract was, well, until we get ready to actually close and have our financing lined up, you got to continue operating your studio in the ordinary course. Well, of course, they shut down because they were mandated to shut down because nobody'd go anyway. And, we all know what we're living through. And so the question becomes, well, is that continuing to operate in the ordinary course? Well, the answer is no, if you define ordinary course by looking in the rearview mirror, but very possibly yes, if this is the new normal, or at least the normal for now. So you get a bit of a feel for this. There's another one of these cases where there was a governor's order that said you have to shut down all the amusement parks. So they shut down the amusement parks. Well, they stopped paying their franchisee for the amusement park they weren't allowed to operate. And so the allegation is, well, yeah, you may have an excuse if you couldn't perform because of a governmental order, but you were ordered to shut down. You weren't ordered to put away your checkbook and stop paying me. So this is a fraught, time-consuming, and expensive path to follow. Our guess, our intuition is this is not the path a lot of people want to follow or can productively follow at this time. Jonathan.
I think that's right. A related variation on this is something called impracticability. So the same sorts of problems might lead someone to say, I can't perform my promise, my contract, because it is impracticable to do so. And courts will then look at a 3-part test to decide whether that's true. Something must have happened, number one, which was assumed not to have occurred in the making of the contract. Number two, that occurrence must specifically make certain performance exceptionally difficult. Number three, the parties could not reasonably have foreseen that the problem could occur. In all cases, these are questions that are obviously important and on people's minds and extremely expensive to have a court answer in a litigated setting. And so we suspect that most people will be better off most of the time trying to negotiate a resolution. Incidentally, this overlaps with a related doctrine called impossibility. Again, you might hear lawyers talk about this stuff. You might hear your contract counterparts talk about this stuff.
Yeah, so impossibility sort of gets at, and one of the questions in terms of, let me back up just a sec to impracticability, it's all well and good to say, well, it's just really hard to do this, so I should be excused. And, well, define really hard, right? I mean, a lot of us are parents and we've asked kids to clean up their rooms or make their beds and they say, I can't, and well, try a little harder and maybe you can pull it off, right? The question, of course, becomes how hard is it reasonable for a court to compel a party to try to abide by the original agreement. And that's going to vary tremendously. And so it's very difficult, again, time consuming and costly to pursue. Impossibility is one of these doctrines that's maybe a little crisper, but again, this is one of those things we don't think you really, many of you are going to want to get into. I use as an example for impossibility, let's suppose I'm hired under a contract and I'm supposed to paint your house, but God forbid, your house burns to the ground. It's impossible for me to paint a house that's no longer there. So that's an example, I think, of a classic example of impossibility of performance. Presumably, it's right that the court let me out of that contract because I literally can't do it. The house is merely damaged a little bit. Well, you know, now we've got things that are a little harder to really come out with in any precision. But I think we want to speak briefly to frustration of purpose, and then we'll sort of transition to our model form itself. Jonathan.
Right, and frustration of purpose, like these other doctrines, is a defense to the obligation to perform under a contract. And it's a slight variation, I guess, on impossibility, where the claim is that the frustrated purpose must have been the principal purpose of the contract, it must be substantial, and the non-occurrence of the frustration must have been a basic assumption of the parties at the time of formation. Of course, nobody had ever thought about COVID, right? Nobody expects the Spanish Inquisition, as our friends in Monty Python would say. So it's, you know, it's not clear what a court would do if confronted with the defense of frustration of purpose. And like all of these other legal positions, we think these are great for lawyers. These are great for litigators to play with, and for folks who want to spend money on lawyers, right? That's something that you can do. But our general view is that in the great majority of cases, it is likely to be more economically productive, socially beneficial for the parties to not throw these legal terms at each other, not fight about these things, but instead try to create a breathing space where they can, you know, discuss amongst themselves what is possible, what is practicable, even if it may be frustrating, so to speak. So let's turn, in other words, as we say, you could litigate about any or all of these things, or you could try something else.
And not incidentally, that something else probably stands a much better chance of preserving what, but for COVID, is going to be, in many instances, a worthwhile and productive business relationship. So, you know, be careful before you burn the bridge you might want to cross again tomorrow.
So this is the beginning of the form of agreement that Norm and I created. And one of the first things to understand about it is that it's intended to be a very user-friendly agreement. It is intended for use by people who are not lawyers. And so it's meant to be straightforward. It's meant to be accessible. We include some fairly standard legal terms, legal mechanisms, because we think that it's important that parties understand that this is a legal commitment, and it would be in many respects taken seriously if, God forbid, it went to court. But nevertheless, we're trying to sort of thread the needle between creating a substitute interim agreement that is manageable for parties who are not necessarily represented by counsel, but still, you know, looks and functions like a real agreement. And a preamble is something that you would see in a real agreement. And so it begins, this agreement, the standstill agreement, is made. This blank key here means the parties literally online can just put in the date that they're making this standstill agreement. And there then is a place in which you can key the name of the debtor and the name of the creditor. So we say, made this 8th day of May, 2020, by and between Jonathan Lipson, debtor, and Norm Powell, creditor. As Norm said, debtor and creditor are simply terms of convenience, debtor meaning the party that owes the performance, creditor meaning the party that is owed the performance. It might involve the payment of money. It might involve the delivery of goods and services. It might involve any number of things. This is intended to be broadly accessible, broadly usable.
And we tried not to go overboard with defined terms and other things like that that tend to excite people like us in other contexts, but a little bit is necessary for clarity. So Jonathan just introduced the term standstill agreement, and intuitively enough, that's what we've called the agreement that people would be entering by use of this form to say, gee, the world changed. Here's how we need to sort of make a few adjustments in the short term while we're standing still. Now let's talk a little bit about another fundamental element or stage within a contract, and that is recitals, or something that sort of sets the stage, tells us why is it that we have this document. And this says, well, listen, the debtor and the creditor are parties to, and this is where we're going to reference the underlying agreement that is or may soon be in default. This is where we're going to reference the loan agreement dated July 10th, 2018, or the supply contract dated September 3rd, 2017, as amended, whatever it might be. And so, lacking in imagination, we've chosen to call that document the underlying agreement. And of course, that may be several documents, you know, one related to another. You sometimes have a loan agreement and a promissory note and other things like that that all sort of ride together and indeed usually sit together in the same binder. So we've just sort of done that for context. And then we've made a reference to the overarching goal of the standstill and tolling agreement, which is effectively that we're going to call a timeout. Neither party is particularly going to take steps that would change things vis-a-vis the other party. So the person entitled to the performance is not going to go to court and sue to try and bring it about or exercise its remedies to seize collateral or what have you, on the one hand. And we'll come to this in a little more detail when we get to that. But briefly, the counterpart, the counter to that, the other side, the party that is in default or about to be in default for want of making a payment, isn't about to indulge in what we call hiding the ball, right? They're not going to do crazy, you know, restructuring of the corporation, change of control, selling their assets. Oh, while you weren't looking, I got rid of everything. The idea is it's a timeout, right? And the ball does not advance down the field or the other way during a timeout. All play stops. People get a better idea what's coming next, catch their breath. So that's what we try to do in these recitals. Jonathan.
Yeah, I think that's a great way of describing it, Norm. And one of the other things that we wanted to accomplish with the language in the recitals is just a reminder to people why we're bothering to do this, why anyone who's entering into this agreement would bother to do it. And that is that there's this extraordinary event caused by the COVID pandemic that has led to, you know, breaches of contract that might invite all sorts of legal action, including lawsuits involving the defenses and claims we've spent a few minutes talking about already. And so, you know, as Norm said, in order to preserve the relationship, avoid the cost and delay of litigation, we're setting the stage for a set of interim temporary agreements as sort of an alternative to the underlying agreement. So the first term in the contract, the model standstill agreement that you would come to, and again, this is all drawn from the online version, which you could go to at your convenience at the ABA's website, the American Bar Association's website, involves what we would call scope. That just means this is telling the parties what we're agreeing to freeze, what we're agreeing not to take legal action on. So this standstill agreement covers the rights and obligations in the underlying agreement, but it does not cover anything else involving any other matters between the parties. So for example, if there's a contract between the parties, but there also happens to be a slip and fall claim, this agreement does not freeze the slip and fall claim, but it would freeze any attempt to take legal action or otherwise, you know, move the ball up and down the field with respect to the underlying agreement. Those issues with respect to the agreement are called the standstill issues. We just define those for convenience. There's nothing magical about it.
So term, the question of course comes up, well, if we're going to call a timeout, how much time are we going to have for the timeout? How long does it last? And here we have one of those key here buttons that contemplates you'll fill in a period of time, say 30 days, 60 days. Now, in fairness, when we were drafting this, I guess about a month ago, we published this on April 13th with the American Bar Association. We thought probably 30 or 60 days would do it and get people to a place where they had much greater clarity. We're not so sure now because heck, 30 of those days are gone. We're not sure, but the nice thing about the way this works is, and it's built right in, folks can continue it even longer. So they're coming up with like a starter period of time here. And they can renew for additional periods of time, same length, different length, you know. They can shorten by their mutual agreement. This is just a place to start. We had thought about keying this specifically to, oh, when the pandemic's over. And then we said, well, gosh, how do you define that? What does that actually mean? And even if you could figure out what that means and how to say it, right? And it's going to differ in different states, and it's going to differ in different lines of endeavor, different fields, as our audience today knows probably far better than we do. We also have the likely reality that even if we could wave a wand and the pandemic is completely over, it's going to take a little time, if not a lot of time, to ramp back up. Right? You don't suddenly get water out of the business end of the garden hose when you turn it on. It takes a little while to run through the pipeline. So we recognize all of those things. So here, term and termination, it calls for a stipulated period of time, 30, 60, 90, whatever, and it allows parties to re-up for additional times or to mutually agree to cut it short or what have you. Jonathan.
Excellent. Thanks, Dan. The third term is one of the two that really, I think, is the teeth and heart of the agreement. And this is the creditor's commitment to stand still and take no legal action for the defined period of time. And in addition, there is an agreement that what is known as a statute of limitations will be tolled, which is just a lawyer's term for the clock has stopped. So we say during, or we would suggest the parties say, during the standstill period, creditor, the party owed the performance, shall not take legal action against the debtor. Any applicable statute of limitation, et cetera, is tolled for whatever the defined or agreed standstill period is. We've also asked or suggested that a creditor agree not to transfer its rights under the underlying agreement or this standstill agreement during the standstill period. So we're saying, creditor, this is where you say you won't take any legal action for a defined period of time. The clock will stop, so you're not losing the opportunity to take that action in the future if you need to, but you're also agreeing not to sell your claim or assign the contract to someone else, at least during the standstill period.
Yeah. And so the next thing we get to is, of course, the reciprocal to that, and this would be the essentially the debtors or the person owing the obligation making certain promises. And they basically sort of boil down to debtor agrees it won't make it worse for a creditor during the standstill period. So the idea being, if you are the one who owes the payment, you're not going to, you know, in the dead of night, liquidate all of your assets and to the detriment of your creditor. You're not going to change the fundamental structure. Let's suppose we had a corporation. We're not going to fundamentally change its structure or kind of sneakily pour all of its assets over into a limited liability company or what have you. This tries to say all of that in sort of broad, sweeping, general language in many contracts. This paragraph, which is fairly short as you see it on the screen, would actually go on for several pages. We thought it was sort of, you know, not ideal, to say it mildly, to do that. We just wanted to sort of summarize, you know, don't be changing the game. A timeout's a timeout, and that's what this is intended to do.
Excellent. Yeah, I think that's right. It's intended to just stop everything. Although you'll notice that at the very beginning, we make reference to the next paragraph, paragraph 5, and the possibility that there might be some relief that is an exception to the non-ordinary course acts that are being halted here or precluded here. And so term 5 is an aspirational provision in the contract, in the sense that we don't really think that a court could enforce it. But what it says is that during the standstill period, the parties agree to engage in good faith negotiations to resolve whatever the standstill issues are, the breach of whatever promise has been breached, and to support one another's efforts to obtain new financing or other relief that may facilitate performance under the underlying agreement. For example, obtaining a PPP loan through the CARES Act. We think that this is very important to say explicitly, even if a court doesn't necessarily enforce it, because we want to encourage parties to engage in this sort of conduct. And we think it further articulates the rationale for having the agreement in the first place. We think that good faith negotiations during a reasonable standstill period likely to produce a much better economic and social outcome than litigation.
And on that note, it's interesting, right? You could understand a creditor taking the position, look, you owe me the money, that's your problem, you figure out how to get it. And that's fair as far as it goes. But one of the points we make in the secured transactions world is, at the end of the day, to use that awful hackneyed phrase, sometimes the creditor kind of is well advised to help his borrower to get on his feet, get his cash flowing, and be in a position to make that payment that's owed. So sometimes it's a little bit of, help me, help you. And we really wanted to sort of signal and shout out to folks that may very well be what this paragraph or term 5 does. This was drafted, of course, at a time when the various federal programs were just starting to find their original form. Many of you who are following those relief efforts may share my view that there have been some rather significant changes in the rules for some of those programs. And I hesitate to say, I'm not suggesting that critically. It takes a lot of time to draft things with great care and freedom from ambiguity. There was, of course, a legitimate need for Congress to act very quickly here. But nonetheless, I think that many people in the business community would agree that the guidance they see now is not necessarily what they would have intuited when these loan programs first came out. So again, just by way of explanation, we kept this pretty general, but the idea was to get people to just slow down and recognize that working together cooperatively may well be the best path for everyone. I'd like to talk a little about the interim consideration, and this in term 6 is our recognition that it may not be a complete shutdown. It may not be a complete standstill. It may be that some performance continues during the standstill period. So taking the say, payment of a loan, it may be I was supposed to pay, or to use Jonathan's example, he was supposed to pay me $1,000 on the first of every month. And it may be that he can reasonably see himself to paying $250. So it may be that here we stipulate that during the standstill period, he'll pay me $250 a month. This does nothing to change his ultimate obligation to pay me the rest. This is just defining what we're going to do for now, either completely standstill or standstill, but for certain things we've specified here. And similarly, we have the reciprocal, right? The debtor may have certain things he's going to do for the creditor. The creditor may have certain things he or she's going to do for the debtor. Again, that's just nomenclatural convenience to use them in drafting. But we may find that there is, in fact, some ongoing performance on either or both sides, and this is where that would be reflected. And if not, this would simply be completed to that effect, not applicable.
Right, you just leave it blank. Term 7 involves breach. We know that we are trying to avoid legalistic things like claims of breach, but of course, for any contract to have any legal significance, it has to be clear that there can be a breach of the promises that are made under it. And so in term 7, we define breach in fairly straightforward ways. Any violation of paragraph 3 That is to say, the creditor's agreement to stand still and not take legal action shall be a creditor breach of this standstill agreement. And we just define the term for convenience. Similarly, by a parity of reasoning, any violation of paragraph 4 by the debtor, that is to say, taking precipitous action like giving the business to your cousin or what have you, will be a debtor breach of this standstill agreement. So just making it clear that there are promises that matter here. Those are the two that we think are most important, those that freeze the relationship in an attempt to preserve it. And those, a violation of either of those would be a breach under the agreement.
And of course, following a section on breach, we speak to remedies. And here we thought, again, simple and straightforward is probably the best approach in this context. So when we speak of what happens if the debtor breaches, this agreement, well, then this deal's off, right? It's really that simple. This deal's off, and the creditor can pick up whatever remedies he wants to do, take whatever action he's otherwise entitled to do under law. And again, by way of parity, to have sort of what's good for the goose is good for the gander, coming at it the other way. If there's a creditor breach, well, what exactly do you do there? And our thinking was, well, if the creditor has agreed not to avail itself of certain rights during the standstill, then if the creditor unilaterally basically blows up the agreement by breaching it, it shouldn't be thereby able to benefit from those things that it gave up, right? Because then you'd have an illusory agreement. I agree to give up certain rights against Jonathan, and then I decide, I don't want to give those up. I'm going to breach, and then I won't have given anything up. Our view and our draft reflects, no, if I were to breach, then I would forfeit those rights that would not have accrued during the standstill period. We just thought that was a fair and simple place to come out. Jonathan.
Yeah, I think that's right. And so the way we envision it, and again, if you go to the ABA's website, you can see an annotated version of this that provides more detail and examples, is that interest would continue to accrue during the standstill period if the agreement already provided for it. The legal right to sue to collect that interest is what's being frozen. And so a question we've gotten is, well, would default interest or penalty interest accrue during this standstill period? And the answer is, it depends on what the world looked like at the moment the parties entered into this agreement. If there had not yet been a default declared, and so the normal rate of interest was accruing, then that's the rate of interest that would continue to accrue during the standstill period. But the creditor couldn't trigger the right to a default rate of interest, and so on. In either case, the thing that the creditor loses, the bite, if you will, on the creditor, is the ability to collect that interest if they breach this agreement. So that's the intuition here. Term 9 involves a little bit of lawyerly stuff, representations and warranties. We thought that, trying to balance the goals of convenience, but sort of serious legal appearance, we needed to have some statement in the agreement that parties really can do this, that they really have the power and the authority to enter into the standstill agreement, and that it would be binding on them according to its terms once executed. And that's all that this is doing. That might be intuitive and obvious to non-lawyers, but if there is trouble under this agreement in the future, we want to make sure that lawyers who read it in the future, or God forbid, judges, don't have questions like, well, did the creditor have the authority to enter into it, et cetera. This anticipates and solves that sort of a problem.
And we'll touch on that topic again when we talk about the key boxes for the signature blocks. But again, one of the things done here is to just invite people to slow down and think about what they might need to do. If you're a corporate party to a contract, you might want to think about what authorizations you need to obtain to enter into the contract. So for those who read, and it's only a few pages in length, so that was another reason we kept it short. The longer it is, the less likely people will actually read it in its entirety. But some of this is just like, oh yeah, that's something I need to think about. So hopefully that's helpful to people. On term 10, this is really not creating any change in rights, but it sort of points out to people, in fact, at this stage in this year, 2020, we do have a variety of both state and federal law that tend to support widely the notion that you can enter into binding legal contracts through electronic means. And that's very important to a lot of people now. They send things back and forth as email attachments, as various forms such as this one that can be completed online, or indeed as emails themselves. But there's both state and federal law in just about every well, the federal, of course, in every jurisdiction, and the state in most jurisdictions, to the effect that if you can sign it with a with a ballpoint pen on a piece of paper, you can probably do it by affixing an authentication on an electronic device, and that should tend to work. So we just wanted to sort of shout that out for people's assurance. Jonathan?
And this becomes especially important in a world where having physical interaction may be problematic. We expect that most parties to these sorts of agreements are not in the same room at the same time. And so the only way they could do this is by going onto the ABA's website and sort of talking through how they want to complete it and then completing it. And this makes it possible for them to do that. Term 11 involves something that might seem completely mundane and bureaucratic, the notices that might be provided under the agreement. But in fact, we think it's moderately important for similar reasons. That is to say that we know that interaction and communication have been disrupted by COVID. And so we wanted to make it very clear how parties shall give notice to one another under this standstill agreement during the standstill period. So we say during the standstill period, the creditor will provide notice to the debtor about this standstill agreement as follows. And you just fill in the little box here, however it is, an email address, a telephone number, whatever it is. That might well be different from the way you would provide notice under the underlying agreement. And then there obviously is a comparable and equal and analogous provision for the debtor to provide notice to the creditor. Again, it is a bit of bureaucracy, but we think it's an important bit of bureaucracy in light of the fact that it may be difficult to stay in touch, and yet it is critical to stay in touch.
Yeah, as an aside, 7 weeks ago, as I started working remotely rather than in my law office in Wilmington, I'd send people emails and say, call me. And then I had to quickly figure out how to forward my office phone to my cell phone because I wasn't there. So this was, again, just a mechanism to help people realize you may not be at the location where you usually were, and you may not readily have access to the, the Dropbox or whatever that you used in the past. So just think about it. How will you get in touch with each other during your standstill period, whatever it might be? That'll take us to one of those mundane things that people don't usually think about, but I'm going to start with a story from my first year of practice. This was a long time ago, and I was looking at a contract, and at the beginning it was, Bob Smith as a party to the contract, and then at the signature line it said Bob Smith, comma, president. And it was a lot of time and money that really didn't need to be spent, but well, we had to figure out whether old Bob Smith himself was a party or whether Bob Smith Enterprises Incorporated was the party. So this is inviting people and sort of keys off the reps and warranties that Jonathan spoke about a moment ago. But this invites people to sort of stop and slow down and say, well, is this Bob Smith or Bob Smith Enterprises? Who should be the party to this? And one assumes, generally speaking, that's going to be whoever was a party to the underlying agreement, right? The second key suggests a key in what kind of entity, and the annotated form gives you a little more guidance on just what goes in here. So we try to help you along the way. But, you know, a limited liability company. Well, many of you are probably organized in that format, and you realize that off the shelf or out of the box, or however you want to say it, limited liability companies have members, and those members tend to run and manage those entities, and they may go other directions and have managers, and, you know, but there's different paradigms, right? There's the corporate paradigm where you have officers, and so this just invites people to sort of slow down a little bit, think about, oh yeah, in this instance I need to be mindful that I'm wearing my corporate hat or my LLC hat or what have you. That's all. It's just intending to slow folks down, get them to focus on what they know full well, but might slip their minds if they move too quickly. Jonathan.
Yeah, I think that's exactly right, Norm. So in the, you know, the sort of top set of 3 boxes, we envision the debtor putting its information, and if, for example, I owed Norm money and I did business through an LLC called, you know, Johnco, then in the very first box, I might key in the word Johnco LLC. And below that, after the letter A, I would indicate what type of entity it was, say a Pennsylvania Limited Liability Company, by, and then the third box key here, by me, by my name as the person who is the authorized person to bind the limited liability company. And again, you just do the same exercise for the creditor, and then you're done. That's essentially the entire agreement in a nutshell.
So I think that brings us to the end of our run through, and we will defer to Christina as to what comes next, what might be useful to our audience today.
Wonderful, gentlemen. Well, thank you so much for that comprehensive presentation. A lot of really great information, excuse me, was shared. We did have 1 or 2 questions. One, you know, and maybe, you know, I think it may be obvious, but maybe not, is that, you know, as government continues to navigate this crisis, you're seeing different states, you know, put in motion, you know, certain contingencies for contractual agreements, whether it be rent, bill paying, whatever it may be. So I assume the advice would be, if you're going to do something like this, keep an eye on what's happening with your state government, because there may be some relief coming statutorily from your respective legislatures. Is that correct?
Yeah, let me take a cut at that, Jonathan, and certainly I'll defer to any thoughts you have as well. But I think that's exactly right. We all want to be mindful that many governments are responding in a variety of ways, some consistently, some different, you know, from one state to another. And being here in the Delaware Valley, we're speaking at least of 3 different states potentially. And of course, this group primarily in South Jersey, but dealing with people perhaps in the other states, right? So we do want to be mindful of that. Now, in many instances, those programs we're going to find may seek to change timing, but may in fact seek to change people's ultimate rights as between one another. And here, of course, we're not looking to truly change in a permanent way people's rights. We're looking for what we've called a timeout. But yes, you certainly want to stay attentive to anything, whether helpful or harmful, that's coming your way through applicable governmental entities.
I think that's right. And so, for example, in a state like the Commonwealth of Pennsylvania, where there are restrictions on the ability to foreclose or evict consumers from their primary residence, right, that is going to have a ripple effect to some significant extent for landlords, commercial, you know, landlords to those tenants, because they're probably not getting rent. And that then ripples back to their lenders, because presumably in many cases, those landlords have borrowed money to build or purchase the buildings that, you know, are occupied by their tenants. And so, you know, actions by the government, whether constraining or, you know, a positive sort like funding, certainly have an effect on this. And it's precisely on the uncertainty both about whether government's going to do these sorts of things, and once it does, what it actually means, is the sort of uncertainty that we think folks want to try to make more manageable. And so we hope that entering into an agreement of this sort will provide them at least a little bit more certainty while things become more clear.
Thank you both for that. I didn't realize we are close to our end time. I did want to get to one question that popped up in the chat. You know, obviously most of our audience are business owners. Many of them are small business owners. And obviously they're paying rent for their businesses that are currently, for the most part, not open, unless they're an essential business, of course. What about claiming unjust enrichment to the building owner? Be seeing the government, you know, shut down their business through no fault of their own. Is that something a business owner could claim?
So I think that becomes analogous to our discussion of force majeure. There's a very understandable visceral reaction, right? When things go horribly differently than what one anticipated and contracted for, when one counterparty is not doing what they agreed to do, and when oneself can't do, right? I mean, why should I pay rent on a building I can't use? And where am I gonna find the money if I can't use the premises to generate my income? But in fact, the vagaries of the law and the contracts are such that it's very challenging, time consuming, time spent, time lapsed, and expense incurred along the way to litigate these issues. It may be the right approach in some instances. It may be a very economically irrational approach in others. In a given instance, it would take a lot of thought and analysis to sort of decide what's right. But certainly it's among the possibilities one might consider. Jonathan?
Yeah, I mean, so the law professor in me loves that question.
You like questions that are hard to answer. That's why.
Because, and this is going to sound like lawyer speak because it is, or law professor speak because it is, but unjust enrichment is what we would call an equitable remedy, meaning that if there is a contract, then in theory, courts shouldn't be considering a claim of unjust enrichment at all. Unjust enrichment is an alternative way of providing a remedy when there is no contract. And so if somebody confers a benefit on another person under certain circumstances where it's unjust to allow the recipient to keep that benefit, well, then there might well be, you know, a reason for providing a remedy of some sort. But courts, as a general matter, say things like, well, if you have a contract, by and large, you don't need to look at that because the whole point is the contract is specifying the benefits and burdens between the parties. But that's just the law professor in me. I think that Norm is right. It's certainly one of many, you know, quivers in, you know, in the litigation arsenal that people would want to shoot at each other if they want to shoot at each other. And, you know, as we say in the article, and you can see the little quote on the final screen, you know, there are lots of important things that we think people can do, you know, in the current crisis, but we don't think that commercial litigation is likely to be one of them. You know, instead, what we're hoping folks can do is create some space and some time to figure out how to adjust, because everybody's going to have to adjust, and the more effective the communication, the lower the blood pressure, the more likely those communications and adjustments are likely to be.
So to pick up on Jonathan's turn of phrase, once people do start shooting at each other, it's hard to go back. That's a difficult day to forget. So we encourage people again, slow down, maybe even stand still, but certainly slow down and think about, yeah, it isn't playing out the way you hoped. It isn't the way anyone anticipated, but indeed it is what it is. So what is the best way forward for you, given what we're facing? Our premise, maybe the best way is to just wait a little longer, so maybe we have a little greater clarity as to when and how the world will start to return to normal.
Well, Norm, I think that's the perfect note to end on. So we are right up against 11:30, and we do like to be respectful of your and our attendees' times. Gentlemen, thank you so much for being with us today. We will be making these slides available We'll also, when we recirculate, when we send the survey, we'll also recirculate the actual article for folks to take another look at in case they didn't have a chance to see it on the front end. But again, thank you so much for being with us. A wealth of really valuable information as business owners continue to try to navigate and get some sense of clarity on this COVID world in which we're all living in. So thank you very much. Thank you to all who joined us today, and everyone have a great rest of your day. We'll see you online soon.
Thank you for the opportunity.
Thank you. Be safe.